Dear viewers, I am Professor Sharanjeet, working at the Rajiv Gandhi National University of Law. I have a teaching experience of over 18 years. In the previous lecture, we discussed the first essential condition for liability under negligence, which is the duty to take care. In this lecture, we shall be focusing on the second essential requirement for invoking the liability for negligence. The second requirement is failure to maintain that standard of care or a breach of duty as is required in a given situation. So, at the very outset, we need to ask, what is a breach of duty in the present context? Breach of duty means non-observance of due care which is required in a particular situation. What is the standard of care required? The standard is that of a reasonable man or a man of ordinary prudence. If the defendant has acted like a reasonably prudent man, there is no negligence. A very important case under this head is Blyth versus Birmingham Waterworks Company, 1856. In this case, Elderson stated that negligence is the omission to do something that a reasonable man, guided by those considerations that ordinarily regulate the conduct of human affairs, would do, or to do something that a prudent and reasonable man would not do. The law requires the question which a prudent man would observe. We owe it to add a higher value to the rule, which requires, in all cases, regard to caution as a man of ordinary prudence could observe. The care taken by a prudent man has always been a letdown. Dear viewers, in this regard, it becomes imperative to determine the meaning of the phrase reasonable or a prudent man. A reasonable man would regulate his conduct so as to avoid producing any undesirable consequences that he could foresee as probable. That is the normal standard of careful conduct. If the conduct in question falls short of that standard, it is negligent. Here a reference can be made to Lord Cooper in Ghanan versus Glassing Corporation, 1950, in which it was observed that it will not equate the reasonable man to the young man in a hurry. A reasonable man is cool and collected and remembers to take precautions for his own safety even in an emergency. An interesting case on the issue of a reasonable man was decided by the Gujarat High Court in Shivkar Mota Singh versus Ram Naresh in 1978. The brief facts of this case were that the defendants, who were school teachers in a municipal school, took part in a picnic party of 60 young school students. The plaintiff's son of 12 years was also one of the young members taken to a picnic on the bank of the river Sabarmati, where the students took their meals jointly. After the students had finished their meals, the defendants started taking the meals together. While they were taking meals, they heard some noise towards the bank of the river, and on reaching there, they found that the plaintiff's son, who happened to be there, drowned and was killed. The plaintiff brought an action against the defendants for negligence. The court held that the defendants were liable for damages. The test that, in the case of this type, should be applied in the test of what a reasonable careful parent would have done in such circumstances. Reasonable care required that the defendants not have started taking their food together. A reasonable careful parent could have never acted in the same manner. After all the boys had finished their food, One of the teachers could have supervised the movement of the immature boys while the others were taking food. In the facts and circumstances of this case, it constituted negligence. Dear viewers, here it is important to note that the law requires taking certain points into consideration to determine the standard of care required. First, the importance of the object to be attained. Second, the magnitude of the risk. And lastly, the amount of consideration for which services etc. are offered. First, we shall discuss the importance of the object sought to be attained. It is important to note that the law does not require the greatest possible care, but the care required is that of a reasonable man under certain circumstances. The law permits taking some measures of risk so that, in the public interest, various kinds of activities should go on. Thus, a certain speed may not be negligent for a fire brigade vehicle, but the same speed may be an act of negligence for another vehicle. The purpose to be served, if sufficiently important, justifies this option of their normal risk. Thus, a balance has to be drawn between the importance and usefulness of an act and the risk created thereby. An important case in this regard is Latimar versus AEC Limited, 1953. Dear viewers, the brief facts of this case were that due to an exceptionally heavy rainstorm, the respondent's factory was flooded with water. Some oily substance got mixed up with water. After the water drained away, an oily film remained on the surface of the floor and the floor surface became slippery. The respondent spread all the available sawdust on the floors to get rid of the oily film, but some areas remained uncovered due to a lack of sawdust supply. The appellant, who was an employee in the respondent's factory, slipped on one such oily patch and was injured. He sued the respondents for negligence and contended that the respondent should have closed down the factory as a precaution until the danger had disappeared. The House of Lords held that the risk created by the slippery floor was not so great as to justify the precaution of closing down the factory with over 4,000 workers. The respondents had acted like prudent men and therefore they were not liable for negligence. Listeners, another important case in this regard is K. Nagareddy versus Government of Andhra Pradesh, 1982. In this case, the plaintiff had an orchard consisting of 285 fruit-bearing trees. The state government constructed a canal under the Naga Arjun Sagar project for irrigation purposes without cementing the floors or the banks of the canal. Due to the absorption of excess water from that canal through the roots, all the trees died. The plaintiff brought an action contending that not cementing the floor of the canal or its sides was negligence, for which the state should be liable. The contention was rejected and it was held that the construction of projects or the laying of canals for irrigation and domestic purposes was a great necessity, particularly in Indian conditions, and without them the land would be wilderness and the country would be a desert, and not cementing the floors or the banks of such a big canal was no negligence on the part of the state government. The plaintiff was, therefore, held not to be entitled to any compensation from the state government. The degree of care required depends on different situations. What may be a careful act in one situation may be a negligent act in another situation. The law does not demand the same amount of care in all the situations. The kind of risk involved determines the precautions that the defendant is expected to take. For instance, a person carrying a loaded gun is expected to take more precautions than a person carrying an ordinary stick. Similarly, the driver of a car is expected to be more careful when it is raining. Similarly, while transporting gasoline, greater care is needed than in the case of transporting water. An important case in this regard is Mysore State Road Transport Corporation versus Albert Disa of the year 1973. Listeners, in this case, the court rightly observed that negligence is a failure to take care. The expression due care connotes the degree of care that a reasonable man is expected to take in a given set of circumstances. What may amount to a negligent act in a particular place and occasion may not be a negligent act in another place or location. In deciding what care was called for in a particular situation, one useful test is to ask how obvious the risk must have been to an ordinary prudent man. The question in each case, therefore, depends on its own facts and circumstances. Another important case is Nirmala versus Tamil Nadu Electricity Board of the year 1984. In this case, a high tension wire running over a farm got snapped, and the plaintiff's husband, who treaded upon the wire, was instantly struck dead by electrocution. It was held that the defendants who were maintaining the said wire had failed to maintain them properly, which made the wire snap, and they had further failed to provide a device whereby the snapped wire would have automatically become dead and harmless. The defendants were held liable for negligence. In the case of Sagar Chand versus State of Jammu and Kashmir, 1999, two children aged about 7 and 11 years were passing through a paddy field in the village as they were going to take a bath. The electric line in that area was under repair. Due to the negligence of the lineman, the children came into contact with live electric wires, got electrocuted, and died. The State Department was held vicariously liable for the negligence of the lineman and was required to pay compensation of rupees 60,000 and rupees 75,000 for the same. Moving further, in another case, Veeran versus Krishnamurthy, 1966, the plaintiff, a boy of about 6, was knocked down by a truck when he was trying to cross the road. About 20 to 25 boys had been waiting to cross the road, and some of them had already crossed the road when the accident occurred. The route was an open road, and the defendant could see from a distance of about 200 yards that the children were about to cross the road. Under the circumstances, it was held that the driver must have foreseen the possibility of the accident, and the same could have been avoided if the driver had driven at such a pace as to enable him to stop before he reached the place where the boy stood to cross the road. The driver of the truck was therefore held to be negligent. In this case, the court observed, in the case of an adult person, an amount of care on his part attributable to a reasonable man in the circumstances may be expected, and correspondingly, the duty of the care may be reduced. In the cases of a child, having regards to its age, its mental development, and other attendant circumstances, not much care can be expected, and accordingly, the duty of care owed then be of a higher standard. It has been settled many times that men must use care when driving vehicles on highways. A special care is called for where pedestrians assembled on the side of the road for crossing are school-going boys of a young age. Dear viewers, now we shall move on to the next requirement, that is the amount of consideration for which the services are offered. The degree of care depends also on the kind of services offered by the defendant and the consideration charged therefore by the plaintiff. For example, if a man purchases a glass of water from a trolley in the street for 10 or 25 paise, he is entitled to safe drinking water, which should ordinarily not infect him. But if a person purchases a mineral water bottle for rupees 10 or rupees 20, then he can justifiably demand a higher degree of purity. The manufacturer of the water bottle cannot be heard to say that so long as he has made it equal to the trolley man's water, he has done his duty. Similarly, a patient admitted to a luxury hospital where the charges are rupees 10,000 a day would be justified in demanding a higher and more sophisticated degree of care, comfort, convenience and recovery than merely sterilization from infection as could be expected in a general ward of a hospital. In the case of Claus Mittelbackert versus East India Hotels Limited, the question of the liability of a five-star hotel arose for a visitor who was seriously injured when he took a dive in the swimming pool. It was observed that there is no difference between a five-star hotel owner and an insurer as far as the safety of the guests is concerned. The court observed that a five-star hotel charging a high or fancy price from its guests possesses a high degree of care as regards the quality and safety of its structure and the services it offers and makes available. Any latent defect in structure or services that is dangerous to the guests would attract strict liability to compensate for consequences flowing from the breach of duty to take care. For the damage caused to the guests of such a hotel, high damages becomes payable. In the present case, the plaintiff got paralyzed while he dived in the swimming pool and after suffered considerable pain and suffering and spending a lot of money on medicines, a special diet and rehabilitation, he died. He was awarded damages amounting to rupees 50 lakh. The principle laid down in this case still stands. Dear viewers, after discussing these aspects, now we will be studying some specific cases of negligence. We shall start with negligence by the bankers. The bank would be liable for negligence if it made a payment on a forged check, as the bank is expected to exercise due care and attention in detecting a forged check. The Supreme Court in Bihar Cooperative D&CM Limited versus Bank of Bihar in 1967 held that where the signatures of the customer on the check are not genuine and the bank is negligent in not detecting the same, it shall be held liable and it would be no valid defense for the bank to argue that it was the negligence of the customer that left the checkbook carelessly so that a third party could use it. Now we shall talk about negligence by the legal professionals. As we all know, lawyers and advocates represent their clients in courts and charge fees for the services rendered by them. Can an advocate be held responsible for negligence? Viewers, it is seen that many times the non-appearance of the advocate or the lawyer before the court on the due date and time does compel the court to pass ex parte orders after giving them a sufficient chance to appear before the court. Where an advocate is unable to appear before the court on behalf of his party, he should depute his junior to handle the case in his absence, or at least appear before the court on the appointed date and time in order to avoid unnecessary adjournment or ex parte judgments. Where the advocate fails to make an alternative arrangement to ensure appearance before the court in his absence, he shall be liable for negligence. In the case of Manjeet Kaul versus Deval Bus Service, 1989, the appellant's husband was killed in a road accident. She filed an appeal for an enhancement of the amount of compensation awarded to her, but her lawyer continuously failed to appear before the court despite several dates being given to him. Nor did he make any alternative arrangements to represent his client. The Court of Appeal therefore passed an ex parte judgment against the appellant. The appeal for rehearing was also dismissed as time barred. The High Court held that the advocate violated the code of conduct prescribed for the advocates, and he was ordered to pay compensation to his client who lost the case because of his sheer negligence. Next is the negligence by the medical professionals. Dear listeners, the courts have time and again emphasized that the hospital authorities are under a duty independent of their vicarious liability to take care to ensure that their treatment units are properly staffed and equipped in order to meet the medical needs of the people. In the case of T.T. Thomas versus Elisa, 1987, the doctor was held liable for breach of duty and negligence for not performing the emergency operation on the patient in order to save his life. In this case, the plaintiff's husband was admitted as an indoor patient in the hospital on 11th of March 1974 for severe pain in his stomach. It was diagnosed as a case of acute appendicitis requiring immediate surgery, but the doctor did not perform the operation as the patient did not consent to it. The patient died 2 days later. The doctor in this case was held liable for negligence as he could not successfully show that the patient had refused to undergo the operation. In not performing the emergency operation, he had committed a breach of duty to take care of the serious patient, which a reasonable doctor would have done under the circumstances of the case. In the 2010 case of Malya Kumar Gangoli versus Sukumar Mukherjee and others, the Supreme Court stated that the doctor cannot be held guilty only because something has gone wrong with the patient, The charge of professional negligence against the medical person is a serious one as it affects his professional status and reputation, and as such, the burden of proof would be more onerous. A doctor cannot be held liable for mischance or misadventure or for an error of judgment in making a choice when two opinions are available. A mistaken diagnosis is not necessarily a negligent diagnosis. Under the law of torts, a medical practitioner can only be held liable in respect of a wrongful diagnosis if his error is so palpably wrong as to prove by itself that it was negligently arrived at, or that it was the result of an absence of reasonable skill and care on his part with regard to the ordinary level of skill in the profession. So with this, we conclude this session, and the last part of the liability under the tort of negligence shall be elaborated upon in the forthcoming lecture. Thank you for patient hearing.